Good afternoon, everybody, and welcome to this afternoon's licensing subcommittee. Before we start to deal with the preliminary issues, can I ask for a nomination and a seconder for chair, please?
I nominate Councillor Lee Mason.
Well, there is only three of us, so I suppose I will second that. Okay.
Thank you, Chair. Then over to you.
Welcome everyone, I am Councillor Lee Mason. Now that licensing subcommittees are meeting again with members physically present, we have put into place appropriate cleansing and social distancing measures, and so you can be rest assured that this meeting is being held in a COVID secure manner. This has included a request for all attendees to have taken an LFD test within 48 hours of the meeting, and the use of NHS Track and Trace app or attendance log, and 2 metres social distancing, the wearing of masks when not seated, and a one-way system in the Guildhall with a temperature check you would have all gone through upon arrival. Limited public seating has now been made available. However, this meeting is also being webcast to allow the public to view remotely if they so wish. May I draw your attention to the fact that this meeting will be live streamed. The public seating area is not in view of the camera used to webcast this meeting. The public making deputations will not be seen on camera, but what they say will be live streamed. Can I please ask members to remain seated throughout the duration of the meeting and to wear a face covering unless seated. Please only use seats that have got a green mark. If the continuous fire alarm sounds, please evacuate the room and public gallery by the stairwells. Do not attempt to use the lifts. Please assemble at Queen Victoria's statue in front of the silk offices. And also, if anyone who has signed in upon arrival could sign out through the Fire Marshal's regulations. Members of the public and press are also permitted to record the meeting on the understanding that if it neither disrupts the meeting nor records those stating explicitly they do not wish to be recorded, which at this meeting is the people making deputations. Please can everyone use the microphones and remember to switch them off when they have finished. I'm now going to ask for us to introduce ourselves around the room. So having started, I'm Councillor Lee Mason, Cosham Ward.
Councillor Tom Coles, Fratton Ward.
Councillor Jason Fazakerley, Nelson Ward.
Jane Didino, Local Democracy Officer.
Nikki Humphreys, Licensing Manager.
My name's Ben Attrell. I'm a solicitor employed by the Council. Good afternoon.
I'm John Walsgrove and I'm the solicitor representing Elegance.
I'm Jasper Lodger, Wiggle and Elegance.
It's the red.
Yeah, Jasper Lodger of Elegance.
Maya, a member of the public.
Dr. Shona Dillon, Aurora Newdawn.
Charlie.
Procedure as it's followed. We have a set procedure going forward, which I'll outline first. We have the summary of the application from the licensing manager. Members may then ask any questions. The applicant may ask any questions, and other persons and deputations may ask any questions of the licensing manager. We'll then have the applicant's case, and members will ask questions, and representatives of the public or deputations may ask questions, and then we'll have the case from the members of the public, which members may ask questions, and the applicant may ask questions, and then we'll have the summing up. So, to begin with, can I hand over to Nikki Humphreys, our licensing manager, to introduce, please.
Thank you, Chair. Members, the purpose of this report and this hearing today is to determine the application for the renewal of a sexual entertainment venue licence in respect of Elegance, located at 1 Granada Road, Southsea. The applicant company in relation to this application is Well Hot Limited. And the recommendation before you is to determine this application to renew the sexual entertainment venue licence in respect of these premises, and also to have regard to your current policy relating to sex establishments. Members, paragraph 3 of your report sets out that the adoption of both your policy and the statutory provisions relating to sexual entertainment venues. Your policy document for you to reference is attached at Appendix A. Paragraph 4 sets out the various background matters that are pertinent to this application. This includes the renewal application itself, which is at Appendix B, and you've also been provided with various copies of the licence itself as exists, and also details of the committee's decision and reasons for granting the original licence in 2018. I would confirm that there have been no objections to the renewal of the licence last year, and that the premises is also licensed under the Licensing Act 2003, and you also have a copy of that licence as part of your papers. In terms of the statutory advertising requirements, I can confirm that the applicant has complied with those statutory measures in respect of the application. In terms of consultation, this was undertaken with various authorities, which included the Chief Officer of Police and ward councillors. Members, we've received no comments from any other authorities other than an objection from the previous ward councillor for the ward. Members, you have received objections, and the Act which governs sexual entertainment licensing provides that any person can object in writing to the licensing authority not later than 28 days after the date the application was made. So persons can make an application within 28 days, and those objections must state in general terms the grounds of the objection to the renewal of the licence, and they must be relevant. To the application, and sections 6 and 7 of the policy gives you more information on those considerations. However, objections based on morals or values must not be considered as part of your deliberations. You have a summary of objections that were received during the 28-day period of consultation, and those are attached as Appendix E. And it's worth pointing out at this point, members, that the Act actually protects the right of objectors to remain anonymous. However, we are able to provide general information concerning where an objector lives, and general grounds of objection are permissible and can be made and have been made available to the applicant. Members, you also received objections after the 28-day period had elapsed. And case law has determined that whilst the Act requires you to consider objections that are lodged in time, it does give you a discretion to take into account late objections should you feel it relevant to do so. And paragraph 7.5 and 7.6 of your report does give you further guidance to members in respect of consideration of late objections. I would also confirm that the applicant's legal representative has been notified of all of the objections received, including the late ones. Appendix F to the report does provide a summary of those late objections in a similar vein to those reported for those received within the 28 days. And you also have Appendix G, which provides a copy of case law which has been referred to by numerous objectors as part of their general grounds. Members, paragraph 8 of the report provides a general summary and interpretation of the legislation. It sets out the various legal definitions about sex establishments. Paragraph 8.4 specifically references the definition of a sexual entertainment venue. And you also have to help you in the papers today as Appendix H, general guidance that has been produced by the government in relation to sexual entertainment venues. And you should also be aware that a licence can be renewed for up to 1 year, or a shorter period can be given if considered necessary. There are two types of grounds that you have available to refuse licences. Those are either statutory refusal, that you have to refuse on that basis, or discretionary refusal of applications. The grounds for the statutory refusal are set out in paragraph 9.1, and I would advise you that those statutory grounds do not apply to this particular application. So therefore, members, you're focused on the second area, which is discretionary refusal. The Act does allow for refusal of licences, but this needs to be carefully considered and balanced reasons must be given should you decide not to renew this licence. And paragraph 10.1 sets out what those grounds for renewal, those discretionary grounds for refusal are. And that is the unsuitability of the applicant, and if the licence would be to be granted, the business will be carried on for the benefit of another person who would not be suitable, so a front man, if you like. That the number of sexual entertainment venues in the relevant locality is equal to or exceeds the number which the local authority consider is appropriate for that locality, or that the renewal would be inappropriate having regard to the character, use, layout or condition of the premises. Members, paragraph 11 sets out in some depth all of the relevant policy guidelines that you could take or must take into account today as your policy. And page 12 of the report also sets out further information provided in relation to the suitability of the applicant due to formal action being taken by Portsmouth City Council in respect of the directors of Wellhot Limited. This action related to a fine being issued under the Housing Act 2004 for use of a property as an HMO, house in multiple occupation, without a licence. Members, paragraph 12 quickly covers the consideration of the application, so it gives you guidance as to what matters you may take into account when considering this today. And paragraph 13 covers the public sector equality duty, which you must be aware that you have a duty to have regard to today when you consider this application and making your decision. Paragraph 15 relates to appeal provisions, but I think Ben would like to add some clarification to the report for you.
Yes, thank you, Nikki. The report simply states that there's a right of appeal to the Magistrates' Court. I think some further detail probably ought to be included there. Paragraph 27, Schedule 3, states that appeals are set out for the applicant or the licence holder, so not all parties, as you may be familiar with in other licensing hearings, and appeals can be made against refusal on grounds specified in paragraphs 12(3)(a) and (b) to the Magistrates' Court and then to the Crown Court. Importantly, paragraphs 12(3)(c) and (d) are not subject to appeal and are only challengeable by way of judicial review. And if I, just to sort of explain that in a more straightforward sense, if I turn back to page 10 and 11 of your report, you'll see the statutory refusal of licences. I think probably mandatory refusal of licences is probably a better heading for 9. That sets out, they don't apply, so you've heard from the licensing manager, so we won't concern ourselves about those, but the discretionary grounds for refusal, it's the final indent, the number of sex establishments in the relevant locality, and then on the next page, all those falling under the next indent. Those two areas cannot be appealed. Those are the ones that can only be judicially reviewed. Hopefully that makes sense, but I'm happy to take any questions.
Do members have any questions of the licensing manager?
In that case, I'll let the licensing manager continue. Are you finished? Or? Yeah, okay.
Cool. Does the applicant or their lawyer have any questions of the licensing manager?
No, thank you, sir.
Do the members of the public have any questions of the licensing manager? No. Okay, in that case, moving on, it's on to the applicant or his lawyer if they'd like to present the case, please.
Thank you, Councillor. Just before I turn to the main part of the deputation concerning the renewal, I'll just briefly mention the late objections, as your licensing officer has confirmed in her report and again this morning. You are, of course, entitled to take into account late objections following the case referred to, and I can confirm on behalf of the applicant we did have those in good time and were able to consider them before today. In my view, I think it's unreasonable that people do make objections late, particularly if they give no explanation as to why those objections have been made late. And I think that is something you need to take into account when deciding when you retire whether to take those objections into account. But the one point I wanted to raise was really the case which decided that late objections could be considered. That the crux of that decision was about the committee taking into account relevant information that was put before them. Now, in my view, having read the summary of the late objections, there aren't any issues raised in those late objections that hadn't already been set out in the objections made in time, nor the licensing officer's report. And in that sense, if you chose not to take into account the late objections, given there is no explanation as to why they were late, and certainly no apology offered as to why they were late, whether they actually do add any further information which you should take into account, or are they simply repetitive of what has already been set out by other objectors. And my view is, if you consider that it is simply a repetitive objection, then you should not take them into account. They were made late, the statutory provisions are there for a reason, and as I say, in that case which said you could take them into account, it was because those late objections in that case actually raised some information which hadn't previously been mentioned. Anyway, I leave that there. It's entirely a matter for you, but something which you do need to consider as part of your decision. So in terms of the applicant's deputation, there's essentially 5 areas I want to cover with you all this morning. So I'll run through what I believe the issues are for you to determine with reference to the law, and that's both the statutory provisions and also the case law. Secondly, to set out the history of the premises, the licence that's been in place and the applicant. Thirdly, to provide some more information about the civil penalty which has been referred to in the licensing officer's report and give you some more background facts to that, because obviously it relates to the fitness of the applicant, one of the grounds on which you could refuse this licence. Fourthly, just to make mention of aspects of your policy, important because a lot of the objections have criticised your policy, and in fact some have suggested that it's not even lawful. And finally, to look at what I would consider really as the crux of your determination in light of those points, and that's whether granting this licence would be inappropriate having regard to the character of the locality, because that principally is the focus of the objections. They are saying that this club has a negative impact on the locality of the area, and I think that's really where the 3 of you will be engaged in discussion around what you've heard this afternoon. So turning to the first issue, which is the law, your licensing officer's report is excellent as it set out very clearly the position with regard to a renewal of a sexual entertainment venue licence. And the statute sets out helpfully the specific grounds on which you can refuse the application, and you've heard there are 2 grounds, statutory grounds and discretionary grounds, and I entirely agree with the licensing officer's report to you that the statutory grounds in this case are not relevant, so you need not concern yourself with them whatsoever, so you can cast those from your mind. You will need to concentrate on the discretionary grounds. And I would say, of those discretionary grounds, 2 are relevant and the 3rd is not. So on page 10 of your report, you see there those are the discretionary grounds set out. My contention is that the second of those paragraphs can be ignored, and that's the one that if the licence were granted, the business to which it relates would be managed by or carried on for the benefit of a person other than the applicant, who would be refused the renewal if he made the application himself. So you've got a copy of the application, you know it's been made by a company and that Mr. Odgler is a director of that company. He's operated the premises with that company since the year 2000, so over 2 decades. He has day-to-day management responsibilities for this premises, even though he does employ a manager, Mr. Fernandez, and Mr. Fernandez has been his manager at the venue for some years as well. So there is no other person receiving any financial benefit from these premises or has any other control other than Mr. Odgler and his company. And further, none of the objectors have raised this ground as a ground for you to refuse the application. So again, along with the statutory grounds, I ask you to ignore that ground and not spend any time considering whether that's a ground on which you can refuse the application, which leaves those 2 other grounds, the fitness of the applicant and whether the grant would be inappropriate having regard to those factors set out on page 11. So the statutory provisions, in my view, are very clear. But before moving on to those discretionary grounds and discussing with you the applicant's case about those, I do just want to refer to what is considered the leading case in this matter, and I do so because it has been raised by a number of the objectors and unfortunately raised in a way which, in fact, in my view, misleads the committee on what that case was about and what the law actually provides. And that's the case of the Crown against Oxford City Council and Spearmint Rhino Ventures UK Limited. A copy of that case is in your report. You may wish to read it or reread it when you retire. I'm just going to run through with you the ratio of that decision, but more importantly, the facts which underpinned that decision, because they are critical to understanding how that case applies as a precedent in this matter. So a number of points arising out of the judgment, but the principal one, and as I say, one relevant to this case, is about the Council's discretion to grant a renewal and whether it's fettered in any way by the decision of a previous committee to grant the licence in the first place. So as you know, Elegance has been licensed for many years. It's had a number of licence renewals, and the case was deciding whether that fact should be taken into account and would fetter the discretion of the committee each year when it came up for renewal. So that judgment confirms a number of other High Court cases and Court of Appeal decisions, which is why I said it's really the leading case now. And it's entirely clear that your discretion is absolute. It's not fettered in any way by the fact that this licence was renewed last year without objection, the year before with a number of objections, and granted the year before that in 2018. So it is a valid point that's raised by the objectors, and I entirely endorse it because that's what the judge has said. Your discretion is absolute. However, the renewal, as you know, can only be refused if there are rational grounds, and your licensing officer referred to your decision making, and if you refuse this licence, setting out the reasons why you would refuse that. Now, in the Oxford case, the facts were very different to the facts which we'll put before you in this application. So in the Oxford case, the licence holder had a sexual entertainment venue licence in Pennyfarthing Place. But on the first time they applied for the renewal of that licence, the licensing committee refused it. The licence holder sought judicial review against Oxford City Council, against refusing to renew it. But during those proceedings, he then applied for a new sexual entertainment venue licence at a different location in Oxpens Road. Now, the committee granted him that application, and so he withdrew his judicial review against the refusal to renew his first licence at Pennyfarthing Place. The council's policy at the time that that licence was granted was that it would be generally inappropriate for a licence to be granted for premises in the vicinity of historic buildings, schools, shopping centres, residential areas or places of worship, so much like your own policy. And the council stated in their reasons for granting the licence at Oxburn Road, whilst the resolution was engaged at low level, there were good reasons to believe the premises would not be inappropriate in the proposed locations. So having taken into account their policy, they granted him the new licence for his new premises at Oxburn Road. It then came up for renewal 12 months later, and the committee refused the renewal of the Oxburn Road's licence. Now, in giving their reasons, it was clear that the committee had before them new evidence that during that first year of operation at Oxburn Road, there'd been a negative impact in the nature and character of the location within the vicinity of his sexual entertainment venue, and a hostile atmosphere and heightened risk of sexual violence had been proved by that new evidence. On the judicial review, having taken the committee for their refusal, the judge quite clearly said that the discretion of the committee was not fettered. That's the principal point of the case. But they must attach weight to the fact that a licence had been granted. However, in that case, he felt the committee had exercised their discretion correctly because they had new evidence before it which hadn't been put to the committee at the initial grant and went directly to the heart of the matter, i.e. the impact on the nature and character of the locality. So it was on the basis that there was new evidence that that appeal was dismissed. His judicial review was dismissed. But the court did make it clear account had to be taken of the fact that the premises was already licensed. But in that case, only for a period of 12 months, and there was fresh evidence that it had had a negative impact. Now in this case, as you'll hear shortly, Elegance has been there for over 20 years. It's been licensed numerous times, it has been opposed numerous times, and on every occasion that I've been before this committee on the grant and renewal of this licence, no new evidence has been brought to this committee to show there has been a negative impact on the locality and character of those premises in the vicinity. And again, I stress, in the objections that you have before you, again, there is no new evidence to support that contention. So moving on, having dealt with the law, let's deal with the next ground, which is the fitness of the applicant. And I need to address you on that for the first time for Mr. Odgler, because as I said, he's an experienced licensee in this city, has been before this committee on a number of occasions, both for Elegance and the other sexual entertainment venue licence he runs at Wiggle, just round the corner. Your licensing officer has referred in her report, and I think one of the late objections mentioned it as well, that a civil penalty had been imposed on Mr. Odgler in relation to an unlicensed house in multiple occupation. Well, I just need to set out a bit more detail with respect to those facts so that you have the full picture. So in relation to the property in question, an officer from Portsmouth City Council inspected those premises on the 10th of December and then wrote to my client's managing agent by email on the 11th of December following that visit, stating that various work had to be completed and that a licence from the council had to be applied for. The agent contacted Mr. Odgler that day on the 11th. An application for the licence was submitted the following day on the 12th, and all of the minor works which were required were completed by close of play on the 12th of December. So the issues which were raised by that officer were dealt with in less than 48 hours from receiving a visit in respect to that property. So you can see Mr. Odgler acted immediately to resolve the matter. He'd not previously owned a house in multiple occupation. This was his first, and he left matters in the hand of his managing agent, much as he's done with this application in leaving the matter to me to make representations on his behalf. He expects those he employs in their field of expertise to do what's necessary to ensure that his business can operate lawfully. When I took instructions from Mr. Odgler, I believe he actually had a defence against that penalty of reasonable excuse. However, he had obviously already taken the decision to pay the penalty so that a line could be drawn under it. You can say he certainly learnt a lesson from it, that he needs to satisfy himself what is required rather than perhaps leave it in the hands of others and make more diligent inquiries. But I would say in relation to that, it doesn't bear any relevance as to whether he is a fit and proper person to run a sexual entertainment venue licence. Not only does he have the two in Portsmouth, but he also has one in Southampton, in Bournemouth and in Weymouth. So 5 in all over many years. Not once has his fitness as an applicant been raised in any of those local authority areas by any objectors, by any responsible authority or by licensing committees. He's vastly experienced in the management of those premises. All licences have been renewed every year for all of those premises. There's never been concern about a breach of conditions of the licence, and as you know, the police have not objected to this application, and if there was any concern around the fitness of Mr. Odgler to run a sexual entertainment licensed venue, then certainly the police would have raised it with you, would have raised those concerns with you, and they have not. So in that respect, I hope you will accept the facts that have been given surrounding that matter, that they don't relate to his competence to run the Elegance premises lawfully, and on that point you can be satisfied. So that leaves us to deal with the second discretionary ground, whether it's inappropriate having regard to the character of the locality, the use to which any premises in the vicinity are put, or the layout, character or condition of the premises. So in relation to those 3 strands, my contention is nothing has changed since the last renewal. In relation to the objectors' references to schools, churches, they mentioned the clubs moving from Southsea, the proximity of residential properties, issues such as parking. Well, none of those matters have changed. The situation is the same, and referring back to the Oxford case, there is no new evidence in any of those objections which would allow you to conclude that it's inappropriate with regard to the character of the locality. Your policy is very clear. You've obviously got a copy of it, and I would ask you to cast your eye over it when you retire to make this decision, and remind yourself that although this City Council does have a nil policy for sexual entertainment venue licences, that is to the exclusion of existing premises with sexual entertainment venue licences. Now, there's some objectors have raised the legality of that policy. Well, that's not a matter for you to consider today at all, in the slightest. If the objectors wish to take this council to task on the legality of its policy, it must do so in the High Court. Bearing in mind the length of time your policy has been in place and no such challenge has ever arisen, I would ask you to cast your mind away from any representation made either in the written representations, or if we hear in due course from the 2 people present that your policy for some reason is not fit for purpose. The policy is fit for purpose. It was decided by your licensing committee. It's been enforced for years, and I ask you to attach weight to it, because in that policy it does say the nil policy excludes those already licensed, which is of course Elegance. So in conclusion, my contention is you have a number of undisputed facts before you, and those are that your policy specifically excludes sexual entertainment venue licences in existence from the nil policy. That's a fact, it can't be disputed. that there's been no change in the locality in the last 3 years that a licence has been renewed by this committee, and you should attach weight to that. There are no police objections and no objections from any other responsible authority or statutory agency, for example, Environmental Health, the Planning Authority. This premises has been and operated as a sexual entertainment venue for the last 20 odd years and has had licences granted by this council since 2018. Its first licence granted under the new legislation actually wasn't granted until 2018, but it's been renewed each year since then. So this committee has on 3 previous occasions determined Mr. Ojala as a fit and proper person, and that he operates 5 sexual entertainment venues across the South Coast, none of which have ever been refused a renewal, either on discretionary grounds of being not a fit and proper person or in relation to the character and nature of the premises. And lastly, you will have read the objections, and you may have picked up on the terminology that many of them use, as I did, where objectors are using words such as it may happen, it would happen if the licence was granted. And in those objections, to me, that makes it clear that the things that they're alleging may or would happen if the licence was granted clearly haven't happened, because they would be able to identify those situations for you and adduce credible evidence that those things are happening already. Obviously, you then have disputed facts, and that's where your time will be engaged when you retire, I'm sure. So some of the disputed facts, and certainly facts which, on behalf of Mr. Ojala, we draw to your attention as being wholly unfounded and in fact defamatory. So any reference to drugs being used at the premises or outside the premises, any allegations of prostitution within or without the premises, a rendezvous for any other illegal or immoral businesses. Any references to criminal activity are disputed and, as I have said, are defamatory. Previous warnings have been given at these renewal hearings about anonymous people coming forward and expressing their opinions as to what they think is going on at this club. As I say, there's absolutely no credible evidence put before you in previous years nor this year that any of those activities are taking place. And as I say, if they were, then of course the police would be involved and they would be drawing them to your attention. This meeting is a public hearing, and although objectors remain anonymous, that should not protect them from being allowed to make defamatory statements against Mr. Ojala and his company. It's probably in dispute that the locality hasn't changed. We say it hasn't. The objectors may put forward evidence that it has. I certainly couldn't find any in any of the written submissions that there'd been any change since the last renewal last year. We may hear more of that in due course. And lastly, as I said, a number of them have put forward the fact that if you granted the licence, you would be breaching your own policy, which of course is not correct. In relation to the disputed facts, they'll only become facts if you hear credible evidence. Otherwise, they are simply expressions of fear or opinion based on nothing at all. And that's what we say the basis of those objections are, because we've heard them, the same objections every year for the last 3 years. They're virtually identical in their allegations they make, yet every year no credible evidence is ever put before this committee that those issues actually arise. And I think a final point to make in that regard is, I think one of the objections is from an organisation called Not Buying It, and they have actually threatened you, the subcommittee, with legal action if you grant this licence. And I would actually say, cast any threat of potential judicial review from your mind. It's wholly inappropriate for any objector to put a committee under pressure by suggesting that their decision would be unlawful. You've got a discretion to exercise. You've heard it's an unfettered discretion, and if you grant it, they could challenge that by judicial review, but that's not a relevant consideration for you. It never should be. Let me conclude by saying that having heard all of that, having read the papers as I have done the letters of objection, my view is very clear that there is every ground to support the grant of this licence, and no substantive grounds have been put forward for you to refuse it. So, councillors, I leave the representations there, but of course myself and Mr. Odgler would be happy to answer any questions that any of you may have. Thank you, councillors.
Thank you very much. Do members have any questions they wish to ask at this point?
I have, sorry. So I do have questions, but not to Mr. Walsgrove, but arising out of what Mr. Walsgrove gave in information to us. This will be to our legal advisor. Thank you. Well, there are four. The first question is confirmation by the council's legal advisor that the council's current arrangements towards SEVs are lawful, because that was questions whether or not we're lawful or not in regards to it. Views by objectors, I believe. Number two, Mr. Walsgrove's detailing the Oxford case. In your opinion, was that correct? Was there anything you believed to be missing or erroneous? And again, no disrespect, I just need to get that clarified. The objectors' comments, or some objectors' comments, about us breaching our own policy in regards to making the decision over that. Can you give us some clarity? And finally, the point that Mr. Walsgrove raised at the end of his speech to us there, presentation to us, the threat of legal action against subcommittee members here, and how do we stand? Thank you.
Thank you, Chair. Nothing quite like being put on the spot. So the current arrangements and their legality, I'm just refreshing my memory. That was in relation to the policy?
Our policy in general, or our policy in fact as a council, Portsmouth City Council,
And
is our
is
policy
this specifically in relation to the nil?
not to this particular application, but in general the point about our policy as a local authority towards the way that we deal with SEVs, is that lawful? I assume it is, but I just want you to tell us.
It is lawful. It is lawful, and I think there's a misunderstanding as to how that operates. The fact that it excludes pre-existing licences at the time that it was implemented is perfectly lawful approach. It's often an approach that's adopted when new measures are implemented in some way or form to protect those businesses that are already running. And the important point to stress, I think, is that the way that the policy operates doesn't actually, and I'm going to use the phrase that's been bandied around, fetty or discretion. At the end of the day, the policy sets out that no new sexual entertainment venue licence will ordinarily be granted. Of course, there are always exceptions to every policy, but that's the presumption that's laid down. And the operation of that is very clearly set out in the policy to the exclusion of existing licences. That's perfectly lawful. There's no issue with that whatsoever. But that doesn't prevent you from considering what the appropriate number of sexual entertainment venue licences is for this particular locality afresh today. It doesn't create a presumption one way or the other. You're totally unfettered. That's my position on our policy. It's perfectly lawful. So the Oxford case, it is set out in the papers, and it may well be worth members taking the time to read through it when you retire, if you've got
Sorry,
particular points. But
I'm sure my colleagues and I have already read it. Well, I know I have. So it wasn't a doubt. I'm grateful for the papers being provided, but I just wanted, as Mr. Walsgrove gave a detailed presentation and he made specific reference to it, I'm just asking you, on the information that he gave to us publicly, was there anything in what he delivered that you believed either to be incorrect or erroneous, or in your opinion, was that a perfectly reasonable
I
presentation?
think it was all perfectly reasonable. I don't think there was anything misleading. I think it was perfectly pitched. Obviously pitched in such a way for the benefit of his client as he's paid to do so, but there's nothing misleading or erroneous or anything that jumps out that I feel you ought to be aware of, that is a contrary point within the text of the judgment. Moving on to the next point, the breaching of our own policy. I think I've covered that, or is there something specific?
Well, kind of in effect you have, but as it was a question, as far as you're aware, we're not breaching our own policy on how we react to this.
Absolutely not. Obviously, how you react, I can't foresee or foretell, but as I've explained, you've got the freedom to determine on those statutory grounds, albeit discretionary statutory grounds, whether to refuse the application or to renew it. And the policy, all policy at the end of the day is guidance. You are always free to depart from policy as long as you have sufficient and clear and cogent reasons for doing so. And those reasons have to be borne out by the evidence that you've heard. So the fourth point was the legal action, and Mr. Walsgrove has set the position precisely as I would advise you. It's not the threat of an appeal as such ought not to bear on your minds whilst you're making your decision. You should be making your decision based on the evidence and the facts that you've heard, and the statutory parameters that are laid down by the law. And bearing in mind, obviously, the duties and the guidance whilst you do so. If there's anything else, I'll happily answer it.
No.
Yeah, thank you. Any other questions from members? In which case, members of the public, do you have any questions you wish to ask of the applicant?
Yeah, I've got a couple of questions, if that's okay, Chair. Thanks. The gentleman argued that there is no new evidence surrounding the location of the Club Elegance. I think it's been licensed now consecutively for 3 years. Can you just confirm how many years the club has been closed for and out of operation?
Well, certainly it's been closed during the COVID restrictions, so from March 2020, and it's still shut. It is expecting to reopen on the 19th of July, subject to the government's decision on whether nightclubs and sexual entertainment venue licences can open. And prior to that, it has been open in every year from the year 2000.
And my second question is around the claim that the licence holder has never been challenged over a sex establishment licence. I don't believe this to be true. I believe that in 2013, a senior licensing officer at Bournemouth, where Mr. Ojla has another club, visited his club Wiggle and saw several conditions being breached, including dancers straddling customers and simulating sex acts. And her report also stated that drug tests carried out in the performers' changing rooms and toilets revealed unacceptably high levels of drug use. And PC Darren Harris, who also visited the venue, said in his report Dorset Police are of the opinion the management and owners of Wiggle have failed in their legal obligations in ensuring the venue is run in accordance with the conditions of the sexual entertainment venue licence and have demonstrated themselves to be unsuitable to operate such a venue. Now, while I understand that the reaction to this particular challenge was that the club owner was given a period of time to improve and no further action was taken, I just wondered, because you told us that no challenge had ever been made to the applicant's suitability to run a venue, whether you have any comments on that. Thank you.
In relation to the comments I made, certainly that was in relation to the renewal of all his SEVs at all those clubs each year. I said that none of those licences had been refused. In relation to the matter which has been raised, that was an objection to a renewal for his club in Bournemouth, and the licensing subcommittee granted the application. The matter hasn't been raised in objections before. In your pack of documents, I certainly hadn't read it, so I was the lawyer that dealt with that case. But I have to say, having new things introduced at the hearing is not something which I'm able to deal with, other than to say to you that those officers did carry out a visit when the application was made to renew the licence. They did object to the grant of the licence, but it was granted and has been granted every year thereafter.
Yes, Chair, I think I probably ought to interject and just at this stage give some legal advice to the subcommittee. Obviously, when fresh material evidence is presented which hasn't been disseminated to all the parties in advance of the hearing, it does place them at a disadvantage, and obviously natural justice and the right to a fair hearing start to kick in. So I do advise that you attach weight accordingly to what you've heard about these additional points that are being raised.
All I would add to that, if the point being made is specific to the fitness of the applicant, and as I think I said, there had been on Elegance certainly no questions raised by the police about the fitness of the applicant in that Bournemouth case, it wasn't a question about the fitness of Mr. Odgler. In that particular premises, he had employed a manager, and I think the responsibility for that particular visit lay at the door of that manager, which is why in the end the committee took the decision they took to renew the licence, Mr. Odgler having sacked the manager that was running those premises. But I think that's as far as I can take it for you today, so it wasn't about Mr. Odgler.
Thank you. Any more questions or at this point, or?
No, just to make a point that this is not about bringing new evidence to the committee. This is, we are entitled to ask questions from the speakers, so I'm putting a question to the speaker. Thank you.
Thank you much. Okay, no further questions, in which case we move on to the deputations from the public. So I'm happy for either of you to go first, but I think...
Thank you. Okay. We are now nearly 10 years on from Portsmouth City Council agreeing to a nil cap policy on sexual entertainment venues, or SEVs. The Council's own SEV policy states that there is no place within the City of Portsmouth of which it could be said that it was situated in a locality in which it would be appropriate to licence a sex establishment. We understand that this decision was then subsequently amended in private by the Licensing Committee in 2012. For 9 years, Aurora, alongside other local campaigners, has asked the Council to reconsider their stance on SEVs and their operation in the city, and to effectively adhere to their own policy. Over the last 9 years, austerity has taken its toll on our city. This is set to increase with the pandemic. Our previous comments and objections remain. By renewing or allowing the licensing of SEVs in the city, the committee is advocating that in times of economic hardship, in fact at any time, it is acceptable and expedient for the local authority to rely on the commodification of female residents to generate income. This is difficult to accept at the best of times, but again, it is even harder to understand given the Council's previous consultation policy and decision on the licensing of SEVs. The Council are fully aware of Mr Olger's inappropriateness as a licence holder in the City, considering he has been fined £18,000 for his unlicensed student property, which was deemed high risk to the 11 young occupants within. Clearly the applicant...
Sorry, I hesitate to interrupt, but you can't say it was high risk because it wasn't high risk, and B, it wasn't £18,000, it was £6,000. You need to, if you're making a deputation, the facts need to be right. Otherwise, I will have to interrupt to put the committee right. I'm sorry about it, sir, but...
So it's my understanding that actually that was taken back to court and he was charged a further £12,000. Oh, I'm sorry, okay, I got that off the newspapers. So incorrect, slash it, but if you'd let me carry on, you would understand where I'm going with this. Clearly the applicant is totally unfit, which can be grounds for refusal, but we would assert the licensing committee can merely lean on its own policy, which means the locality is unsuitable, because your own policy states that no strip clubs will be near places of worship, children's centres or similar. On this basis, the SEV is in a highly inappropriate locality. It is next to 2 schools and a church. The area is also rife with vulnerable adults and multi-occupancy dwellings. Women have told you at previous hearings that they are harassed outside it, which clearly affects their ability to use the area comfortably, if at all. We know that our colleagues at Not Buying It have detailed for you why your own interpretation of the law is incorrect and have supplied you with the case law to evidence its correct interpretation. We would also like to point out to you that in recent months, in both Blackpool and Bristol, in March and April, respectively, councils have banned strip clubs in their localities. I sincerely hope it doesn't take another 9 years for Portsmouth City Council to prioritise women and girls in their city. Thank you.
Okay, thank you very much. I understand you need to get away, so if we do your questions back first, and that way, yeah. Are there any questions from members? No. Does the applicant have any questions to ask? No. In which case, you're welcome to stay, or if you need to get away, you'll... Cool. Can I invite, if you'd like to do your presentation, please?
Yeah, thanks very much, Chair. So I used to live at the bottom of Waverley Road, and I eventually moved away because I'm one of those women that the location became a no-go area for. But I'm not really going to focus on me today. I would say that the discussion around people that are objecting to these applications being deemed to be making threats of legal action to the committee is completely false. I think that it's absolutely fair that members of the public and other institutions should be able to bring to the attention of the committee the real legal grounds that they could be facing if they continue to license these clubs. So it's not about making threats, it's about giving you information and, you know, backing up what we're saying about our own experiences, really. But I'm going to talk about your policy, which states that there is no place in Portsmouth that is suitable for a lap dancing club. This is indeed true of the site of Elegance, which is in a dense residential area near 2 schools, a church, many HMOs with vulnerable adults. Many women, including myself, but not limited to me, have written and spoken before telling you that they have been harassed outside these clubs. Your policy states that the presumption to refuse does not apply to existing clubs. However, this clause, wherever it's come from, still only goes so far as to reiterate SEV case law. This means that regard should be given to the existing licence, but the council does appear to be wrongly interpreting this to mean that existing clubs cannot be refused, and that's just not the case. This interpretation is unlawful and in breach of SEV legislation, and I don't believe that anybody here wants to interpret our own policy in that way. The SEV legislation, which says that pre-existing clubs cannot be treated differently from the new applications. An objection on page 128 of your pack provides examples of case law, and some of that has been spoken about today, that your legal team have obviously been referring to when advising you. In fact, the Council has sweeping powers to refuse existing licences on the grounds of locality. Your policy clearly sets this out. All you have to do is give the applicant the reason why. Nothing is preventing you from refusing to renew this licence on the grounds of locality, and the club has no legal grounds whatsoever to challenge the decision through the Magistrates' Court. No attempt to challenge an existing licence refusal has ever been successful in the High Court. In fact, they are frequently thrown out, and this sets a clear precedent. The Council must abide by the public sector equality duty, and the Council is breaching equality law by licensing strip clubs. If your equality impact assessment does not take into account the extensive evidence from women reporting locally that they are harassed, from women formerly in the industry, and the widely evidenced research of the links between lap dancing with prostitution and sexual violence, then it is undoubtedly in breach of equality law. There have now been 2 successful High Court cases against Sheffield City Council for failing to abide by equality law, and Portsmouth will be leaving itself wide open to a legal challenge if it continues to relicense lap dancing clubs. So in summary, if Portsmouth relicenses this club, I believe that it will be in breach of SEV legislation and equality law. So I'm asking you please to refuse this licence renewal on the grounds of locality. That's really important. I don't believe that this club has been open for a number of years now, at least 4, possibly longer, unless it's been used for private functions. That's simply not true, and that's why Mr. Ojala tried to open a club in Albert Road. Section 10.1 of the Licensing Officer's report in your pack states that discretionary refusal is permitted. The number of sex establishments is currently higher than the number which the local authority considers appropriate, this number being 0. Also, section 11.6 of the report in your pack sets out the points relating to the character of the locality that you may consider when refusing this application. Like I say, this particular club has been closed for around 4 years or more now. There are numerous objections in your pack objecting on the grounds of locality, and arguments such as the club increasing employment in the area, they're just not relevant at a licensing hearing. We all know what's relevant at a licensing hearing by now. So this decision must be made on locality alone, and it must take into account the fact that existing licences under SEV legislation cannot be treated any differently to new licence applications. So it really is time for this club that is in the heart of beautiful Southsea to be removed on a permanent basis. Thank you.
Thank you very much. Members, do you have any questions?
I don't have... Extremely frustrating throat. Thank you for the deputations. I don't actually have a question of the individual making the or either individual that made the deputation, but again, sorry for this, legal advisor. It comes to you because of directly what's been said in regards to that, in particular that last deputation. Can you just inform us as a committee? I think I know where I stand on this, i.e. my interpretation of it, but has been mentioned the issue of pre-existing clubs, which clearly Elegance is, where we are in regards to SEV legislation and equality law in considering this application for this particular club. Now I understand it, that I can, obviously my colleagues, their own interpretation, make their own decision on this, but I'm aware I can either reject this or I can not reject it. So, but can you just tell us directly with what's said of that final presentation, deputation, where we are in regards to pre-existing clubs and the decision that we can make today? Thank you.
Yeah, I mean, all I can really do is reiterate what I've already told you, and that is that the policy that has been established is one that sets a presumption that new licences will not be granted. That obviously can be overridden in certain circumstances, as can any policy. That's a presumption that's put in place, and the policy excludes pre-existing licences from that part of the policy. In terms of how you approach it, excluding that from your mindset, because I don't think it's a relevant factor. Certainly not that part of the policy. The policy generally, of course, you will have to apply. You do still have considerable discretion to refuse the licence if you feel that the evidence warrants it. The grounds that we've already run through are quite extensive about the locality, the use to which the premises are put, the layout, character or condition of the premises, and also what the appropriate number of sex establishment venues is for that locality. You do still have, as I've said repeatedly, and I think perhaps those making objections have missed that point whilst I've been advising you. Your discretion has not been fettered. You do still have the power to refuse or not to grant the renewal licence, but of course you need to have credible evidence on which to base that decision and to justify that decision, and you need to be able to give cogent reasons for that decision. So I think in terms of the policy, that's where we are. The equality duty has been mentioned, and it was something that I was going to advise you on in any event. Clearly, and it's set out in full in the report, and I'm sure you will refresh your memories of precisely all that, and it's not simply a matter of discrimination in terms of sex. There's obviously religion and a whole host of other grounds that you need to be. It's a duty that applies to any function that the authority undertakes. It's omnipresent, if you like, and you always need to bear that in mind whilst you're making your decision. It is possible that if women in the locality feel uneasy, and there is some evidence, some limited evidence of that within the representations that have been made, real evidence as such, and I'm sure Mr. Walsgrove will want to address you on that in summing up probably, then you are duty bound to take that into consideration, but you are also required to balance that against the business needs in terms of what is actually a legitimate business. It's a lawful business, so you're not determining whether sexual entertainment venues as a concept should or can continue to operate or ought to operate in today's society. That is not the remit of this subcommittee today. What you're determining is whether it's appropriate for this licence to continue in this particular locality and whether this particular applicant is suitable to run that premises. I hope that is a clear answer, but obviously if you've got further questions I'll happily answer.
Very comprehensive answer. It's okay for me, thank you.
Okay. Does the applicant have any questions they wish to ask? Okay. In which case we move on now swiftly to the summing up. So it's the public deputations are allowed to sum up first, if you'd like to do it before you go. Or, do you have anything you wish to sum up on? This opportunity to have the final.
I didn't realise that I had an opportunity to sum up. I think just to reiterate the points that I don't think anyone's suggesting that our own policy, that we're in breach of our own policy. I think that important clause there around being able to, with basically having to have regards to the existing licence doesn't automatically mean that it needs to be renewed. And actually within SEV case law and SEV licensing law, you have every discretion to refuse a repeat application. And yeah, in terms of evidence and presenting new evidence, we've been presenting evidence for years. This club has been closed for years as well, so you know it's no surprise really that there's no new evidence since the last licence renewal. However, we're not looking backwards in time. I think, with everything that's going on with Sarah Everard, with a heightened awareness, with the city applying to become white ribbon status again, we need to move forward. So anything that's happened in the past, we just need to move forward and now is the time really to say enough is enough. People don't want this licence, they don't want this club at the bottom of Waverley Road, right near the beach, right near the tourist attractions, near 2 schools, near a church. We don't want it. So, on the grounds of locality alone, you can make that decision. Let's refuse this licence today.
Thank you very much.
Yeah, just a very quick comment to support what Charlie said. In terms of sexual harassment claims, we know that actually, and experiences of women, we know that actually many women won't officially report, but it is what they experience in their daily lives. So it's not good enough for us to rely on the fact that we don't have any quantitative data in terms of the criminal justice system for this club. Women have come forward and explained their experiences to you, and that's really important to take note of, particularly in recent times. Thank you very much.
Okay, thank you very much. And now move on to the applicant, if you wish to sum up as well, please.
Just picking up on that last point, obviously I've dealt with this club for many years and dealt with the previous renewals, and I don't ever remember anybody coming along and giving an account of what they'd experienced negatively outside the premises. Yes, in the anonymous written objections, people referred to drugs, prostitution, etc., etc., but this committee has never had a witness before it saying what the impact has been on their life locally. So that's a misrepresentation for a start. Secondly, in relation to the law, I think everybody's agreed. So you've got a complete discretion. My point in referring in such great depth to the law was because the people who've mentioned all the cases have misrepresented the law to you in their representation. And despite the fact that you were reassured that there's no threat of legal action, in the specific objection that the lady referred to, there is very clearly a threat of legal action where it says Portsmouth's equally liable to costly legal challenge. And then about 2 minutes after she'd said there wasn't such a threat, actually then suggested to you, you will be subject to a threat of legal challenge. So there is that. It's about a completely unfettered discretion, but in taking into account that case which decided it, understanding the facts, and the facts of that case was a new licence was granted, and 12 months later the committee saw what the impact of that club had on that specific location and had evidence before it from witnesses who had given first-hand accounts of how their lives had changed from the impact from that club. And the court found that on the basis of that new evidence there were rational grounds to refuse it. But it also said, as a matter of law, you must take account of the fact, and it's a question of weight, you must take account of the fact that it was previously licensed. Well, in that case, clearly the new evidence outweighed substantially the fact that it had previously been licensed, and so accordingly the judge upheld the decision. And Oxford didn't have a policy which, as yours does, excluded existing sexual entertainment venue licences. And as I said to you, that policy is not under challenge here and cannot be challenged. It's a valid policy. It's been in place for a good many years. And if there is the right place to challenge that, that is on an appeal. So it's not right to raise that as a relevant consideration for you. Your legal advisor has said you have an unfettered discretion and policy is only guidance, which is true. Policy is only guidance. However, you do have to take it into account, and my contention is you should be attaching weight to it. It was a carefully drafted policy after substantial public consultation and debate by the licensing committee, and you are a licensing subcommittee now giving weight to that policy. The three of you completely unfettered as to what weight that should be given. I'm asking you to attach considerable weight to it. There was and must have been a reason why this council decided to exclude at that time the 3 sexual entertainment venue licences that were operating in the city. Now you only have 2. Mr. Odgler's, the third one, has long since disappeared. But going back to the principal issue, which is the character of the locality, so the discretionary ground you've got to refuse it. As I say, the premises has been there for 2 decades. You can certainly attach weight to that, not just a single year in the legal case that they've referred to. The locality hasn't changed for many, many years. You can attach weight to your policy and should do so, and also attach weight to the fact that the police have not made a representation. And if the issues raised, and I know the suggestion is that not everything would be reported, and I entirely accept that fact, but nonetheless, if the allegations of the serious crime that has been alleged was taking place at these premises, then of course the police would have objected it. Against that, you have no new evidence to say that this premises is having an adverse impact. And the fact that the representative suggests to you that the premises has been closed for the last 4 years, to me just sums up our case perfectly, that it doesn't have any impact on the locality whatsoever, because the premises hasn't been closed for 4 years. It's been closed since COVID, March 2020, through to today. So what's that, 14, 15 months. So in the previous 2.5 years that it's said to have been closed, it was open and was operating, and clearly wasn't having an impact if people think it was shut. So on that basis, and on the basis of the law, I ask you to renew the licence for a further 12 months. Thank you, councillors.
Okay, thank you very much. Public deputation and the applicants both happy they've had ample opportunity to say everything they wish to? Yep. In which case we now suspend the meeting to a time I'd suggest not before 3 p.m. Are you happy with that? So, okay, and we have to ask you all to withdraw. We won't start before 3 p.m. We might start later than that, but I think we've got everyone's contact details, don't we? So, okay.